Hi, I'm Brown-Emberton, and this is going to be a resource for you to help develop your opening statement. This is a presentation that's going to go over the key elements and fundamentals of an opening statement, the things that you don't want to forget about when you develop your own opening statement. It's going to be posted in the lessons area for the opening statement development lesson. You should refer back to it. There are some documents in here and other links that you'll want to review. So let's get started. Okay, opening statement fundamentals. So first of all, the opening statement is an opportunity for you to set the tone for the entire mediation. Usually a mediation is tense. This is your opportunity as the mediator to remind counsel, if there are attorneys present, to remind them the process of mediation, and also to educate clients. Many people have never been into mediation before, much less know what a mediation is. I've included a checklist here. Many mediators like to keep this right in front of them while they're mediating, just to make sure they've hit all the key points. Probably the most important here, I've highlighted the rights and entitlements of for people. If you refer back to this presentation, you can grab this document. Make sure you hit every one of these points in your own mediation in some form or fashion. There's also some resources for sample mediations at the Department of Veteran Affairs website. They have a lot of different forms, sample forms at that website. It's a good resource. Okay, parts of an opening statement. First of all, it would be the introductions. You want to welcome everybody there, introduce yourself, ask them how they would like to be referred to. A good example is, thank you for coming to the mediation today. My name is Chris. I'll be your mediator, and I'm going to write down your names here. What would you like to, how would you like me to call you? Mr. Smith, or is Joe okay? You know, and write these things down so you have it in front of you, you know, because halfway through the mediation you don't want to forget somebody's name. Also, just explain where the bathrooms are, remind them to turn their cell phones on vibrate. Comfort questions are questions to try to create a yes environment. You want to start creating an environment that people are positive, not a no environment. No, I'm not going to do this. So ask them if they're comfortable, if the temperature's okay. You know, make sure they're feeling like they're being taken care of. So the prerequisites of getting started, these are things you just want to make sure you cover before the mediation gets started. Does anybody have time requirements? Do they need to be gone by a certain time? These things can drag out longer than you really expect. So make sure everybody in the room knows if somebody has to leave. Also, this is the time that you need to make sure that everybody is in the room that can make a decision on an agreement. You don't want to find out after 3 hours or 4 hours of mediation and you're ready to come have everybody sign an agreement that one party realizes, well, I can't sign this. Papa Joe needs to sign this. He's the one that actually needs to really make this decision. Both parties need to sign an agreement to mediate. It's just showing that they've been there, that it's proof that they were present, and that they attempted to come to a negotiation, or they attempted to negotiate to come to an agreement. After all that's taken care of, you're ready to go through the mediation process and explain to them what to expect throughout the session. The role of the mediator, when they're going to be able to speak, the way I always set it up, and it's normal, is after your opening statement, the plaintiff will have an opportunity to present while they're there. Usually it's the person making the claim against the other party. They will have an uninterrupted opportunity to speak, and then the defendant will have an uninterrupted opportunity to speak. Please don't. Sometimes it's a good idea to have the mediation process printed out so they can read through it, and if they have any questions, this is the time to ask. Rights and entitlements, they need to understand that everything in the mediation is confidential. What is said in the mediation cannot be used in court. So if there's any kind of negotiations or anything put on the table, if they don't come to an agreement, it goes to court, it starts all over. That offer is off the table. The mediator cannot speak about the mediation. Also make sure you explain that any notes you take are only for yourself and that the notes will be destroyed after the mediation. This is also a good time to explain caucus and that you will meet with each party in a private room if it's necessary, and everything in this caucus is also confidential. Make sure you ask what you can disclose to the other party before you leave the room with the person that you've been caucusing with. They're there on a voluntary basis, even though it might be a court-ordered mediation and they've come and they've agreed to mediate. It's their right to call a break. If they need a break, they can ask for a caucus. And also if they decide that it's not going anywhere, they can call an impasse. But it is, even if it's a court-ordered, they do have the right to walk away. You as the mediator are a neutral party. You cannot give any legal or financial advice, and they need to make sure that they understand that you are not an attorney. And if you are an attorney and you're holding a mediation, you're not representing either party. So if you can, it's a thin line of giving legal, what the law is as far as giving legal advice. As the mediator, you don't want to give any advice. You can ask questions. You can pose ideas, things that they haven't thought about, what possibly could happen in court. Otherwise, you are a neutral party. The mediator is there only to facilitate. Each party has the right to have the capacity to make an agreement scheduled. So what happens if they come to an agreement, and what happens if they don't? And so if they come to an agreement, the mediator can write up a binding written agreement and both parties sign it. If it's a court-ordered mediation, then the judge will sign it as well and the claim will be dismissed. If there is any kind of payment plan in the written agreement and one party breaks it, the other party can bring the agreement to court and a judgment will be placed against the party that broke the agreement. If no agreement's made and there's an impasse, then the case will be assigned to the court and the judge will hear it and then the judge will make the decision. This is an excellent example of an opening statement. She's very thorough about the process and what to expect and how they will move through the mediation. It's a little bit lengthy. Your opening statement does not need to be this long, but it's definitely a good reference tool. She hits all of the points on the checklist. Okay, so that is the fundamentals of an opening statement. I hope this helps you develop your own, and I look forward to seeing them. Thank you.